Negotiable Instruments Act, Section 35, Liability of Indusor. Section 35 of the Negotiable Instruments Act, 1881 defines the extent of liability undertaken by an indusor of a negotiable instrument. It clarifies the circumstances in which an indusor becomes responsible for payment and the conditions subject to which such liability arises. 1. Absence of contract to the contrary. The section begins with the phrase, "in the absence of a contract to the contrary." This means that the liability described under this provision will apply unless the indusor has expressly entered into an agreement limiting or excluding his responsibility. If there is no special contract modifying the obligation, the statutory rule governs the indusor's liability. 2. Endorsement and delivery before maturity. Where a person endorses and delivers a negotiable instrument before it reaches maturity, he undertakes a specific legal obligation. Endorsement involves signing the instrument, usually on the back, with the intention of transferring it to another person. Delivery completes the transfer and passes title to the transferee. By indussing and delivering the instrument, the indusor becomes liable to subsequent holders under certain conditions. 3. No express exclusion or conditional liability. The liability of the indusor arises unless, in the endorsement itself, he expressly excludes his own liability or makes it conditional. An indusor may protect himself by clearly stating words such as, "without recourse," or by otherwise indicating that he does not intend to incur liability. In the absence of such express exclusion or condition, the indusor is presumed to undertake responsibility in accordance with the Act. 4. Nature of liability to subsequent holders. The indusor is bound to every subsequent holder of the instrument. This means that any person who lawfully acquires the instrument after the endorsement is entitled to rely upon the indusor's obligation. If the instrument is dishonored by the drawee, acceptor, or maker, the indusor must compensate the holder for any loss or damage caused by such dishonor. Thus, the indusor's liability is secondary in nature, as the primary liability rests with the maker in the case of a promissory note or the acceptor in the case of a bill of exchange, but if they fail to pay, the indusor becomes liable to make good the amount. 5. Condition of notice of dishonor. The liability of the indusor is subject to an important condition. Due notice of dishonor must be given to him or received by him in accordance with the provisions of the Act. Notice of dishonor informs the indusor that the instrument has not been accepted or paid. Without proper notice, the indusor may be discharged from liability, unless the case falls within statutory exceptions. Thus, timely communication is essential to enforce the indusor's responsibility. 6. Liability of indusor after dishonor. The section further provides that every indusor after dishonor is liable as upon an instrument payable on demand. This means that if a person endorses the instrument after it has already been dishonored, his liability is immediate and enforceable upon demand, rather than being tied to a future date of maturity. In such cases, the instrument is treated, for the purpose of liability, as if it were payable on demand. For more details, contact us.